Som.
Tá? Só apertar aqui. Aí sempre que não estiver usando, aperta aqui.
Em primeiro plano, agradecer a visita dos professores que nos brindam, nos honram com a sua especial presença em nosso evento hoje e também cumprimentar todos aqueles que estão acompanhando o evento em casa. Em especial também o professor Luiz Eduardo Gaio, que hoje não pôde estar presente conosco, mas nos acompanha remotamente. Para compor a nossa mesa diretora de hoje, eu convido o professor doutor Rodrigo, por favor, Rodrigo Ribeiro de Souza, professor do nosso curso de Administração e Administração Pública, aqui da FCA da Unicamp. Convido agora para compor a mesa também o professor Kuzma Kiti. Professor Kuzma é professor associado de Direito Empresarial no Departamento da Universidade Estadual de Moscou, diretor executivo da própria universidade e também diretor do Centro de Direito. Na sequência, convidamos também o Dr. Fausto de Santis. É desembargador federal do Tribunal Regional Federal da Terceira Região. Terceira Região, São Paulo e Mato Grosso do Sul. E também convidamos o doutor, o professor. Eu não vou saber pronunciar, mas eu vou tentar. Depois me corrijam. Seong-wook Ryu é professor da Faculdade de Direito da Universidade Nacional de Seul. Por favor. Composta a mesa, o professor Rodrigo está com a palavra para fazer a abertura e as considerações iniciais.
Obrigado, professor João Augusto. Boa noite a todas as pessoas que nos acompanham aqui presencialmente e também remotamente pelo YouTube da FCA. Então quero agradecer, reforçar os agradecimentos ao professor João Augusto, né, ao professor Luiz Eduardo Gaio, a professora Luciana Cordeiro de Souza, também ao professor Rafael Dias, da DERE, né, do Departamento de Relações Internacionais da Unicamp, sem o qual essa palestra, esse nosso evento não seria possível. Então, explicar um pouquinho como vai ser a nossa dinâmica hoje. Nós temos essa oportunidade de estar aqui com especialistas nesta área de compras públicas, né? Então, nosso evento hoje vai ser transcorrer da seguinte maneira. O professor Kuzma vai proferir a palestra que ele preparou sobre esse tema, em inglês, porque ele é da Rússia, de Moscou, da Universidade Estadual de Moscou, que é a maior universidade da Rússia, e ele vai falar em inglês. Aqueles que estiverem aqui puderem acompanhar em inglês todos os detalhes, podem fazer as perguntas ao final. Os que estão em casa vão ter a oportunidade também de ter a tradução imediata, simultânea de legendas em português. E se vocês depois quiserem recuperar algum conteúdo perdido aqui por alguma especificidade da língua inglesa, vocês podem também depois acessar no YouTube, que vai ficar salvo no YouTube da FCA, para acompanhar com a legenda, né? Então, primeiramente a palestra do professor Kuzma, depois as perguntas do Dr. Fausto e do Seung-ho, que vai também fazer alguns comentários ao final. Tá bom? Então, sem mais demora, agradecendo mais uma vez pela presença, né, de um tão ilustre convidado, o professor Kuzma Kiti, que vem lá de Moscou. Passo a palavra, então, para que ele possa nos brindar aí com essa palestra em inglês. Muito obrigado, professor.
Can I go? Yes.
Hello, dear friends. First of all, thank you for the invitation to this university. As we know, Unicamp is one of the famous and interesting university in Brazil. And it's a great honor for us to be here, and not for me, but for my friends from Seoul National University and from Brazilian system. Our friend Fausto Martin de Sanctis, he is famous not only in Brazil, but in Russia too, because he took some very important decision in Russian political sphere and passed criminal decisions against one of very famous Russian criminals. But it was 15 and 20 years ago. Maybe he will talk about it. Today is the first day of our activities in Brazil with our friend Son Uho. And the topic of my speech today is public law and public procurement law in Russia. Why we have this topic? It is interesting because maybe you know that procurement law is one of the famous and very interesting branch of legislation and branch of law in the world. And you know that Russia and Brazil is the members of BRICS, and we try to coordinate our legislation with each other. And we research the legislation of more than 30 countries in the world, and see that Brazilian procurement system and Russian procurement system are very close. Why it's very close? Because we have the same branches of procurements in Russia and Brazil. But I will talk about it after maybe 2 minutes. First of all, I would like to ask by myself, procurement law, is it public law or is it private law? When our Japanese and our friends, professors come to Lomonosov Moscow State University, maybe it's better to speak. They was very surprised when they saw that I'm an associate professor of business law department, but not administrative law department. And they asked me how you can have studies on procurement law and business law during the business law lessons. And I told them that in former Soviet countries we have procurement law courses in our business law courses. And they said that in whole the world it is administrative law. And we tried to decide the question, public law or private law is procurement law. And we get the next information. According to Roman law, according to Cels, private law, it is the law which protect private interests, and public law, it's the law which protect public interests. So if we will see the procurement stages, we will see that it begins on public interests and the ends with private interests. So it's complicated, and we can say that mostly it's public law, but the very important part of this system, it is private system, it's private interests and private law. So why we have the same systems in Russia and in Brazil? Because only in our countries there are two special laws in this sphere. The first law in Russia, as you can see on screen, named contract system law, and the second is federal law number 223. In Brazil, you have the same situation. The first law is the law about state order or state procurement, state and municipal procurement. It was passed in 2002, 21. It's new law. The previous one was number 8666, very easy to remember the number of this law, 666. It was passed in 1993. And the second law, it is the law about corporate procurement. It was passed in 2016. I'm talking about Brazilian legislation. And according to state procurement law, the customers are legal entities which are government agencies, and according to Russian Federal Law number 223 and Brazilian law about company laws, the customers are different companies with state participation. State participation on the other hand, and state agencies from one hand, it is they have difference in their procurement obligations and in procurement structure. For example, if you have procurements purchases with state agency or municipal agency, all rules you can see in this law, in this legislation. But if you want to have procurements according to corporate procurement legislation, you must see their own procurement regulations, and as you can understand, there are a lot of freedom. They have a lot of freedom, these legal entities. As I can say, there is no the same situation, the same regulation in other countries. For example, if we are talking about Japan, Japan has only one domain procurement law, according to which they have no regulation in different questions. And when I was in internship in Japan, I told them, for example, that they have no norms according to which they protect their national goods and services. And Japanese professors told me that where I take this information. I told them that I took this information in their legislation because they have no norms about protection. And they answered me on this information that yes, they have no norms, they have no legislation norms, but they have tradition. They have tradition to protect national goods and services. And they explained me how is it possible in practice. And I was really surprised because it is impossible in Russia, for example, because it's prohibited according to our federal law on protection of competition. But it is possible in Japan. When we research legislation on public procurement of South Korea, Republic of Korea, we saw that there are two different laws in this sphere, but not like in Russia and Brazil. It's totally different. The first law in South Korea about procurements named about state procurement, and the second law named about municipal procurement. And we were really surprised because according to Russian legislation, we have no difference between municipal contract and state contract. But in South Korea, we can see this type of contracts, and they are different, state contract and municipal contract. The second thing that we saw in South Korea was that the South Korea procurement system is centralized. In all countries, we can see decentralized procurement systems. Each university, each legal entities, each legal agencies have its own procurements. Someone like it, someone dislike it. But in South Korea, there are a special service named procurement service of Republic of Korea, which have procurements, organized purchases for all customers. But as we can see in scientific articles of our Korean friends, the Ministry of Military have its own purchase and not give this power to public procurement service of Republic of Korea. What about China? China, it is very interesting country. From one hand, China is economic gigant. Is it correct? Gigant. And it's growing up very fast, and it's economic number 1 or number 2 in the world, from one hand. From the second hand, if you will see articles from Chinese scientists in the sphere of public procurement, all of them write that our procurement legislation terrible. And you will see that, for example, our terrible, but in South Korea is good. If you will read the South Korean articles, you will see that our legislation is very bad, but in Japan maybe it's better. If you will see Japanese articles, they write that Japanese is very bad, maybe in US it's better. And in each country, in US, the same situation. In Russia, the same situation. Every scientists in all countries thought that their procurement legislation is worst. And in other countries, you can see the better one. That's why it's interesting to learn the legislation in the different fields of different countries, of course. For example, BRICS. According to Chinese, I took a decision for myself. How you can explain this difference? For one hand, it is economic gigant. From the other hand, very bad legislation. How you can understand it? How you can explain it? And I took decision for myself, as I said before, that the main role in the field of procurement and in other spheres in China played Communistic Party of China, because the representatives of this party in all procurement committees have a lot of rights, and they can take decision in different stages of procurement without answers of another members of this committee. For example, they can choose the winner of tender. They can change the norms of contract, and etc., etc., etc. They can change plan of procurement, but we can't see this situation in other countries. For example, in Russia, in Brazil. Do you have Communistic Party of Brazil? No, Communist Party of Brazil. No? Yes, but they have no such power like in China, no? Yes, totally different. But we are, Brazil and China and Russia, we are member of BRICS. But our regulation is very different. What we can see in other countries, I will not talk about each country we research, but the most interesting thing it is on the regulation in European Union and in Eurasian Economic Union. If you will see Economic Union, there are special normative acts named declaration on procurements. And according to these special acts, each lawyer have to choose if it has power today or it's not. It is necessary for answering this question to go to special website of European Union and look on this decree, not declaration, but decree. And if one parliament of one country of European Union yesterday cancelled his signature under this decree, it doesn't work today. It is the feature of these norms in the European Union. In Eurasian Economic Union, we have another situation. We have a special agreement of 2014, according to which all 5 countries, only 5 countries, Russia, Belarus, Kazakhstan, Kyrgyz Republic, and Armenia, we have our own legislation in the field of procurement, but we must incorporate it in our economic union. It's very difficult, complicated question. I forgot Belarus, of course. Russia and Belarus, we are very close to each other. And we have problems with Belarus almost. So it's difficult to tell about other countries, Kyrgyzstan, Armenia, and etc. So the main idea which I want to say you that in all countries we have totally different procurement system and totally different procurement legislation. But at the same time, there are in Union nations special normative act, typical normative law about procurement. First of it, about procurement goods of services. First of it was adopted in 1994 in New York, and the second one was adopted in 2011 in Vienna. According to which documents, each country must adopt his own procurement law, according to which customers are government agencies, state participation organization, and etc., according to which every country have next methods of procurement, auctions, concurses, request of quotation, and competitive negotiations, for example, and etc., etc., etc. So, from the other hand, we know how look procurement in other countries because of typical United Nations law. From the other hand, each country has its own features and has its own answers on difficult questions you can see in practice. Oh, it's not interesting slide, I think. If you want to know the difference between these laws in Russia and Brazil, you can compare customers according to first law and to the second law. And I ask my students to know this difference between customers, because if you know the difference between customers, you are the specialists in the field of procurement, the lowest degree, of course, but you are the specialist already. What is the difference I told you? According to contract system law, all rules you see directly in this law, according to law number 223, and Brazil have the same situation. All norms you must read in your own procurement regulations. Each country has its own information system in the field of procurement. In Russia, we have a main site with very special domain name. It was born in 2004 when Russia has politic to go to the West. That's why it is not English and it is not Russian. Zakupki it's Russian word, named means procurement, but in Latin book words, letters. Gov, it's a short version of government, as we can understand. So it is Ranglish. It's like a Ranglish. And if we will have the opportunity to change the domain name of this site, I think in this year, in this political situation, we will change it. For example, Gov to GOS, because GOS is the short version of государство. It's a Russian word named government or state. So it's the main Russian procurement site. According to, if you will go there, you will see all procurements. But if you want to take participation in this procurement, you have to go to special electronic platforms. Before the war of 2022, we have only open electronic platforms and only one closed electronic platform. But from 2022, our government took decision to improve our closed electronic platforms because of Western sanctions to the most important customers. That's why now we have 8 open electronic platforms and 3 closed electronic platforms. If we're talking about public law, it is necessary to say something about criminal aspects of this field. We have a joke every day at our university that if you are a professor of business law, it is necessary to know criminal law very well. And when I was a student on the second course, I was the best student in criminal law. And I thought that I will go to criminal law, but I don't know how I became the associate professor of business law. And the famous professors in criminal law and criminal procedure law, they are very good specialists in civil law because it's very closed spheres in Russia, maybe in Brazil too. If you have battle one legal entity versus another legal entity, speaking about very high cost of this battle, mostly you will see that there are criminal cases, criminal procedure, criminal avocados, no? Not only civil. So if we are talking about the liability for violations in the field of procurement, you can see disciplinary, civil law, administrative and criminal law liability. And from 2018, it was few new criminal articles in our criminal code. I will talk about it later. The common types of fraud in procurement in Russia you can see on your screen, on our screen. Sorry, it's not a Zoom. I tried to translate Battering Ram into Portuguese, but my friend Fausto told me that it's not correct translation. Because that's why I have a picture too there. Battering ram, it means the situation when you are the member of auction. As you know, the modern auctions, they are only electronic auctions. And you see the start of this auction and see a lot of changes of this price from another participation of this auction. If you see it, it means that you see battering ram. And it is necessary for you to press button at least one time and have your proposal in this auction. Because if you will not push the button and you will not and you have not this proposal, the first and the second winners of these auctions, they will not sign the contract. The information about it will go to a special register, blacklist of legal entities, and the contract will sign third place, which press the button only one time, and so this legal entity will get this contract on the highest price. Yes, we have general articles in the Russian criminal code against fraud and corruption. You can see it at the screen. But as I told you, in 2018, we get some special articles. For example, for abuse in the sphere of procurement of goods, works and services for state and municipal needs. And there are special information about this crime. For example, if we're talking about the article number 204, you can see the objective side, violation for legislation on the contract system in the field of procurement for state and municipal needs in different parts. It's okay, I think that you can compare Russian rubles and Brazilian reals. The subject, different types of subject, because in our general articles you can't find the different types of subject. Circumstances, of course, the subjective side is direct and indirect intent, and different type of sanctions. What about sanctions? For example, if we're talking about China, China have the most difficult, the most hard sanctions for criminals in the field of procurement, because corruption, for corruption in China you can see death penalty. And it is a very strange situation. From one hand, the most worst penalty for these crimes. From the other hand, you can see that every year there are a lot of death penalties for corruptions in China. How you can explain it? And Chinese specialists write the next answer on this question. The answer is that we have no normal system in the sphere of administrative law. Administrative law is, and I think you know that some of specialists think that criminal law is a part of administrative law. I don't know in Brazil, is it popular opinion or not? And they write a lot of articles about administrative responsibility, that we have no normal system of administrative responsibility in procurement law, in procurement legislation, and we have to improve it in this sphere. And if we have no the administrative responsibility, a lot of officials thought that, oh, there is no responsibility, I can do everything I wish. And after that, they catched and death penalty. Very strange stories. So in the end of my speech, I understand that it is not interesting to hear me with my English more than 30 minutes. I'd like to say you that we have a special a new norm about public control. It is very interesting for Russians. Why? Because we have it only in our new redaction of our contract system law. In first redaction it was not, and we get its amendments after great political scandal, according to which one of opposite political made special website in the internet, according to which everyone have the opportunity to make a claim in the field of procurement, even if he is not a participant of this procurement event. And one of officials who have this claim, he took decision to go to the Supreme Court of Russian Federation and with the idea to prohibit these public control legal entities to make such claims. And our Supreme Court took a difficult decision, I think. From the other hand, it was officials who damaged law. I forgot how to in English say it correctly. And from the other hand, it was opposite politic who make good things because he have anti-corruption idea. And Supreme Court of Russian Federation took decision to support opposite politic because it's true, it's necessary to do something with this problem, this corruption. And after that decision, we have a special rules, have special article and norms about public control. And now we can see in Russia a lot of legal entities who make only these activities, public control in the sphere of procurement. But after that we have another problem. Some of them became take money for make a lot of public control in this sphere, and they blocked normal activities of normal customers. And the last slide, I think, it's the current problems in the field of procurement in Russia now. Of course, we have different types of problems. Some of them have no decision more than 13 years. For example, we have 2 registers of unfair suppliers or blacklists. It's very strange situation. Unfair supplier, he is unfair. Why we have 2 unfair suppliers registers? So, according to one law and according to the second law, it's strange situation. And for example, our Lomonosov Moscow State University, we have double status, procurement status. We are customers according to contract system law when we have budget money, and we are customers according to 223 law when we have unbudget money, for example, when we take it for students according to contract. And imagine this situation. If, for example, one legal entity, it is the member of first register on affair supplier and not the member of the second. And our university have 2 procurements for with a difference of 5 minutes. Now we have a procurement according to 44 law, and after that according to 223 law. Now we said to him that you are unfair supplier, go away, take away your papers because you're unfair supplier. And after 5 minutes we said, oh, please come to us. Yes, you're a winner. Everything is all right. Because we have 2 registers on unfair supplier. It's very strange and stupid situation. And unfortunately we have some kind of problem. And in 2012, when our law number 223 was passed, I have a special conversation with the author of one of the author of this law and the representative of Federal Anti-Monopoly Service, and I asked him, what's this? Is it mistake or not? He told, oh, of course it's mistake. We will make amendments during 2 months. It was in 2012. Now 2025, we have the same situation in law number 223. and everybody knows that we have 2 registers, and nobody asks already this question to public sphere, what we have to do. Which one is interesting? I think maybe the problem of December. I don't know if you have the same problem in Brazil. December is very difficult month in Russia because we have a budget rule according to which if you have a budget money and you didn't have a yeah, I forgot. Spend it, yes, and you didn't spend it already, and you will have problem in January. Do you have this problem? Yes? Oh, we have the same problem, the same legislation, the same problem. And nobody knows how to decide this problem. Because if you are, for example, university and you didn't spend all your budget money in this year, you will take less money in second year, and everybody knows it. And I ask special representatives of Ministry of Finance of the Russian Federation if it is possible to change this budget rule according to which it is necessary to spend all money. And they said me, if we will make such amendments, all our financial system is crashed because a lot of relations have a special roots in this question. So I think it's enough for me because a little bit not interesting. It's a little bit, I think, because procurement law, it's not popular law. I think you have no lessons, special lessons about procurement law. In our university, we have a procurement law center, but we have no procurement law lessons in bachelor. But in master's degree, if you want to get master's degree on business law department, it is necessary for you to have our special seminars in this sphere. And I want to say one more thing. I arrived only today, and my luggage, my air company stayed in Casablanca. In Morocco, yes. They forgot my luggage. That's why today's morning I got to the shop and buy shoes. And it was interesting experience. That's why are you talking about it? That's why I have no our books on procurement law which I have in my luggage. I want to give it to your university procurement books in English. But only one thing, and another gifts, of course. I have note, but with myself. But I have one very special gift which was with me, not in luggage. How to say it in English? What you have to go to aircraft? What? Carry-on luggage. Thank you very much. In carry-on luggage, I've got one thing. We can say that it is, maybe it's a gift. It's a journal in Russian language where we can see our friend Fausto Martin de Sanctis. He gave us the interview in Russian language. It's a joke. We translated in Russian about Brazilian procurement law. And thanks to our friend Faust, we know a lot about Brazilian procurement law. And all I said you today is thanks to Fausto Martin de Sanctis. So if it is possible, it is our gift for your university today, because all another gifts, they are in Morocco right now, but I hope they will deliver it after tomorrow. Our company called me already and say about. So thank you very much. If you have any questions, I will try to answer. Yes, please.
How important is it to the government to create mechanisms that stop exponential growth of larger companies, of course, before they become large companies, due to the bad effects they can possibly have on the economy and society as a whole? Repeat?
It's slowly, please.
Okay, sorry.
I arrived only today.
How important is it for the government to create mechanisms that stop exponential growth of large companies, of course, before they come...
Explanation of what?
Exponential growth of large companies before they become large companies, due to the bad effects they can have on the economy and society as a whole.
Кто-нибудь говорит по-русски в этом зале? Нет? Unfortunately, I can't understand the growth of the company. How Russian government controlled and protect big legal entities with state participation?
Not necessarily Russian government, like all governments.
All governments. So I think that we have the same instruments. For example, maybe you have the same named golden. Сейчас как называется-то, господи, сейчас. Special right of government to have special decisions in the most important legal entities. A government share, a golden share. Do you have golden share in your corporate legislation? No?
We have different kind of shares, but I don't think we have
Golden
like
share,
golden shares.
it's not a share.
Oh, okay.
It's in
the government participation on the company. Yeah.
Yes. Only not only legal entities with state participation, but legal entities in the most important spheres, for example, atomic energy, or producing military and weapons, and if concerns with infrastructure, they have a golden share, according to Russian legislation, and a Russian government took decision in the most important sphere of activities of these legal entities. In the field of procurement too, of course. And if you are, for example, customer of law number 223, but the 90% of them, they are customers of law number 223. Government passed your procurement regulations and have a total control on your procurements. Of course.
Okay, thank you.
I answer your question.
So you were talking about procurement. I was not familiar with the word or the concept. Well, I was here, but just to see if I understand what you meant, you were talking about the acquisition of whatever the government needs through bidding, right? Yeah, okay, so I do understand the concept a little bit, and I wanted to ask another question. You were talking about the legislation that the population can have some sort of control over what happens in these biddings in Russia. Is that right? So you can, in Russia, as a member of the population, accuse someone of corruption or something of the sort via some sort of channel in these biddings. Is that right? Like, as a legal entity, you can accuse someone of corruption in these bidding wars, or is that not correct? I didn't really understand what was on the slide, but what I saw is that legal entities and the population can say that someone is corrupting these biddings. Is that right? I'm not really sure. Yeah.
Yes, you are right, but according to Russian legislation, if you want to have a claim, you have only to two ways, one of two ways, choose. The first way is to make a special legal entity which have rights to have public control, special legal entity. And the second one, you can send your claim to this special legal entity which made not by you. Or you can, the third way, you can send your claim to Federal Anti-Monopoly Service, but Federal Anti-Monopoly Service will make something with this claim only if you are participant of this tender. If you are not participant, it's prohibited. That's why if you are not participants, please find somebody who have public control and send this claim to that legal entity.
In Brazil we don't have that, as far as I know, but I wanted to ask if it's effective. Does it work effectively to stop corruption in these procurements, or does it not?
I think effective it's not this situation, but the transparency of this whole system. When we adopt the procurement laws, the first effective was a lot of scandals. Why? And population thought, oh, if we have scandal, we have bad legislation. But the answer totally different. No, if you have scandals, it means that you have transparency system. That's why you have scandals. But you have transparency system because you have good legislation. After these scandals, criminals understood that it's not good to have to make crimes in the field of procurement. That's why the number of scandals became more and more less.
I never saw it through the goggles of if you have scandals that are public, it's because the legislation is good. So thanks for clarifying that.
Mm-hmm. Thank you.
What sorts of negative impacts do you think those problems have on Russia's international relations?
Negative effect in public procurement system according to international relations?
Yes.
Yes, of course we have problems. We have disadvantages and disadvantages after 2022. I told to my friends already about it. For example, our cars became more expensive. 5 years ago, my car costs 1 million rubles, and now it costs 2 million rubles. But it is Russian car. We are not talking about cars from other countries. The cost is more than two price. We have problems with our credit cards. For example, I have credit card, a Russian credit card. It doesn't work in Brazil and in other countries. It works only in Russia. But 5 years ago, it works in other countries too. That's why I have another credit card. I made it in another country, former Soviet country, but it works in Brazil and in other countries. And we have problems with our aircrafts, and now we try to produce it. We have problems in other fields, but we have advantages too. Our producing of goods and services, Russian goods and services, are growing up extremely, and not price. Not price. I mean producing. Yes, manufacturers and etc. which placed in Russia. In previous years, we bought 70% of goods and services in other countries, but now 90% I think it's we bought in Russia and Eurasian Economic Union too. And we have a problem with in procurement system because in previous time we have norms, we have no restrictions for buying international foreign goods and services, but now we have a lot of restrictions, a lot of laws, according to which customers can have opportunity to buy only Russian goods and services. By the way, according to China's legislation, without any war, they have norms according to which if you are customer in China, you can buy foreign goods and services only in situation if there are no analogs in China. And it sounds like a joke, analog in China, yes? But we had the same situation in State Military Order Act. We have it 10 years ago, but now I think we are close to China in this sphere because it is necessary to buy only Russian things because of sanctions, because of independence, security of your goods and services. Thank you.
Thank you for the lecture. Yeah, I want to ask you, you mentioned some international regulations between European Union, Eurasian countries. Does BRICS countries have some regulations in the procurement law between these countries? Or if not, you see the need for this to exist?
Thank you for your question. No, we have no any agreements between us about procurements, and it will be difficult to do something with it. But I want to say that if we're talking about first countries in BRICS, Brazil, Russia, India, China, and South Africa, according to my opinion, Russian legislation and Brazilian legislation is the best. For example, in India there is no procurement legislation at all. And in China, a very strange procurement legislation with a lot of problems. And if we're talking about South Africa, we can see that South Africa have problems according to which it's hard to imagine it in Russia, for example.
You mentioned Russian and Chinese national laws about what the customers can buy from other countries. In this situation, you don't see the interest by these countries to make this happen between BRICS?
I think China is not interesting. Russians things except maybe weapons and gas. That's why it's impossible to have agreements with China and Russia in the field of procurement. Moreover, China is very aggressive in economic sphere, as you understand, and too many Chinese goods and services are in the global market. And Russian government try to secure Russians producers against, I think, firstly Chinese producers, because they are everywhere, and it is difficult. A lot of Russian legal entities try to participate in our tenders with information that, oh, it's Russian product. But if you look on it, you can see that it is not Russian, it's Chinese. That's why it's a complicated question.
Thanks.
Спасибо.
Anyone? No? So thank you very much, Professor Kuzma, once again. E dando prosseguimento, rapidamente, vou passar a palavra aqui para o nosso outro convidado, o professor Dr. Fausto De Santis, que é atualmente desembargador federal no Tribunal Regional Federal da Terceira Região. É um grande especialista, uma referência nacional e internacional, que mostra aqui as relações que ele já tem com outros países no combate à corrupção. Tem livros publicados a respeito da lavagem de dinheiro e, recentemente, um livro de 2 volumes que está se tornando já um sucesso de vendas ligado aos crimes federais. Uma referência nessa área. Então, a área de corrupção, justamente associada às compras públicas, que a gente acabou de ouvir o funcionamento na Rússia, comparando com o Brasil. Então, professor Fausto, agradeço muito por ter acompanhado aqui o professor Kuzma. Já é amigo do professor Kuzma de longa data, né? Estava nos contando que o professor Kuzma esteve aqui durante a pandemia, dias antes da pandemia, por isso não pôde conhecer tanto o Brasil. Dessa vez ele está aqui conosco. E então eu passo a palavra ao professor Fausto, agradecendo demais pela presença, por estar conosco aqui, vindo com compromissos tão sempre muito requisitados, né? Segunda-feira, inclusive, o professor Fausto estava contando que ele estará em São Paulo, no Tribunal de Contas do município, com o presidente do Supremo Tribunal Federal, com novamente o professor Kuzma, discutindo a corrupção nas compras públicas. Então, nós estamos realmente falando de pessoas especialistas nesse tema. Então, professor Fausto, agradeço as palavras que puder nos proferir nesse dia.
So, first of all, I'd like to thank Professor Rodrigo. He welcomed me very warmly. So thank you very much. I'm so glad to share this table with Sang and also Kuzma Kishi. And now they became friends. They are very nice person, very important professionals in their field. And I was not prepared for this, but what I could talk, according to the questions and also what Kuzma said during his speech, I congratulate you for your speech, it was very nice. So I could say something based on my judicial practice. So I'm not specialized in public procurement, but I studied a lot of criminal proceedings and faced and still facing some frauds involving procurement acts. The more the system are ruled, the more you have legislation, control,
the more I see frauds. So controlling, you said, India, there is no control. Brazil, you have a legislation similar to Russia. A lot of rules, a lot of this, establishing all the steps for a good transparency and the legislation about procurements. And you see still frauds in the same way in the past as you see now. So, what is the point? In Brazil, we have a lot of scandals. I don't know a lot of scandals involve procurements. We saw recently a big scandal. For instance, car wash operation. I'm not politician. Please don't remove all politics aspects of this. I faced the car wash as a judge in car wash in São Paulo. So why? Because we had 270 hours of testimony from who was a defendant who came to the judge and also the federal prosecutor and said, I want to review the scheme. The fraud scheme involved all the procurements inside the Petrobras, for instance. So, we have transparency. Yes, you belong to the open state policy. It was an agreement between Brazil and the US, United States, that all steps and information about procurements is on net. You can see the values, the price, but how? He asked, someone asked, how to control when you see millions of reais coming to pay a company in a very specialized purchase that you cannot know. How a single person can control the amount going to a hospital to buy medical equipment, medical stuff. So it's impossible to control. Even you can find on internet all the information because it's so specialized things that you have. For instance, in state-owned companies. So you have, like Kuzma said, you have two laws: State-Owned Companies Act, and you have the general law. That's now it's 14133, the number of the new law. It's similar to the previous law, but with a little bit more control over the steps of the procurement legislation. So, Kuzma mentioned some frauds and crimes involving procurements. But the steps, when you see the steps in the crimes itself, you can see that you need at least a collusion, a plot between bidders, between also the officials, public officials. So when you have a plot and bidders, how to discover fraud when all these steps were respecting according to the law? You have the companies, you have the price, sometimes it's the smaller price, you have the judgment criteria, everything is respected by, under the law. So the only way to discover collusion is the way that we have a tool, a criminal tool, to review the scheme. Who can review the scheme? The criminal, revealing the scheme that he belongs to, and he's afraid of being punished. So, plea bargain system that we adopted in Brazil, plea bargaining, that's why we discovered fraud in Petrobras, and also before, because I faced some cases, fraud cases, involving biddings, before the car wash cases. but it was reviewed when the criminal said, I want to review this because I'm afraid of the penalty of the law. But now in Brazil, what is strange, that we know the crime, you know the author of the crime, the criminal, you know the fact, this is confessed, and then it comes to the judiciary, oh, sorry, but there is a nullity here, there is a wrong step that a judge, a prosecutor, every time I see this, even though you go to one way or another way, respecting the procedure, but when it goes up to the Superior Court says, oh, sorry, but you know, here you need to dismiss this case because there is a wrong procedure that was not followed by the federal prosecutor, federal judge. So when you live in a corrupt environment, like you live in we live in Brazil, when I'm saying about corrupt environment, I'm not saying about public officials. I'm saying about private companies, inside private companies, inside public companies, mixed capital companies, families, groups, social groups. We want to take advantage of another person. So you have corruption, you have criminal environment, so it's very hard to detect fraud, and when you detect fraud, there is a way to hide this from the society, and the truth everyone knows, everyone feels, but there is no consequence. So what happens today? We don't see anymore plea bargainings as we saw before, because what are the consequences of law in Brazil? There are no consequences. Now, I am a federal appeals judge, and the Federal Appeals Court has jurisdictions over the frauds involving mayors. So, what kind of frauds we facing of cases involving procurement, fraud in procurements? So, mayors that contract ONGs, ONGs, como que fala ONGs? ONGs, yes, NPOs, ONGs, that they are responsible to administration of a hospital or for a small, not a hospital, but a small service, medical service, local service, and they are controlling everything and deviating money and taking money from the states and not providing the service that they promised to provide according to the contract with the municipalities. So we need to reflect all on our system, especially what responsible as a human being. Because it's very easy to say, the state, the certain company, this and that, but when you don't see ourselves, what we are doing to the neighbor, so we are not going to fix, you can have any kind of laws, sorry, it's a kind of, como fala, desabafo, né? But that is the truth, because I face this, the cases are revealed, it's in front of us, everything is proven, and then you have a single decision. Last week, I was removed from a criminal case because I just, an example, I just summoned a criminal respecting the decision of the Brazilian Supreme Court. I just summoned the defendant because there was an accusation, indictment, and I was just respecting. When I was in the first instance, I decided to summon according to the decision of the Brazilian Supreme Court, and they said, oh, I'm summoning you because you have an accusation in the Brazilian Supreme Court. So the case, I didn't do anything. I just summoned, respecting the decision of the STF, the Brazilian Supreme Court. So they removed me last week on Friday, and a single example, because they said, I have an impediment, how do you say in English? I cannot deal with this case because I'm contaminated. Can you imagine this today? What are you looking on TV? What they are doing? The justices of the Brazilian Supreme Court, they make interviews talking about the case. They make meetings with defendants. They made this, and that. They are perfect to judge the case. I didn't do anything in terms of the merits of the case, and I was based on the jurisprudence, Brazilian jurisprudence. But they decided to remove me in a big money laundering case. Why? Because they don't want an independent judge. That's it. So congratulations to Kuzma, and I hope to hear now Sang to say something about your system. Thank you very much.
Thank you very much, Professor Fausto, and thank you for talking in English. I thought we were going to talk in Portuguese, but it was perfect. So now we'll hear a few words, it's not as you wish, from Professor Sung-Hoo Heo. It's okay? Sung-Hoo.
Lembra do sangue?
Sangue
humano?
Okay. Sorry. So he's from Seoul National University, and he'll talk a few words about procurement, maybe in South Korea. Thank you.
Thank you, Rodriguez and Kuzma and Fausto. So good evening, everyone. So, but actually, I arrived in Brazil last night. So I feel like this is good morning because in Seoul this is 8 a.m. So after the wonderful lecture by Kuzma and the comment from Judge Foster, so let me add some, how to say, public law perspective on these issues and maybe add some my viewpoint. So in my view, so including procurement law or public law in general, so it's about resource allocation issues, because we all, whether in Brazil or in Russia or in Korea, so we are all living in the same conditions, like the scarcity of our resources compared to our huge kind of desires and wants. Because as human beings, we have such a huge desires and wants and needs, but compared to that, we have very restricted resources all around us. So in that sense, we have to think about efficiency or equality or equity in normative sense. So that is kind of the basic concept or functions of public law. So in thinking about these resource allocations or efficiency, so economics can be a good starting point because they did a lot of work, how to organize markets and how kind of individuals or companies can do their best in making rational choice to achieve the efficiency or optimality issues. And maybe in procurement process, yes, the government or state can be, in one side, understood as just one individual participating in the kind of competition process. But because the public sector is quite different from just private market, so some special regulation and special legislation is required to rule on this kind of, how to say, market failure issues. So, and this kind of public regulation issues or administrative law has been developed quite a lot to understand and to do something about this kind of market failure. So this market failures comes from maybe, how to say, externality, like environmental issues, or how to say, information assimilability, etc., or public goods, and etc. So, and yes, many kind of lawyers and economists did all great jobs to develop ways to solve these issues. But so let me say there's some new issues and challenges in these kind of public law issues. For example, environmental law issues, or global warming, or climate change issues, or COVID situations, which has been unexperienced for all our human beings. So these kinds of new challenges of topics has its essence, the risk issues, which means we are all under the uncertainty issues. So we don't know, we didn't know what to do. For example, actually I was invited by Fausto 5 years ago, that was 2020, the starting point of COVID. So I fly from Seoul to California, and after that, I was scheduled to fly to Sao Paulo. But right 2 days before that flight, the big COVID happened in South Korea. So at that time, yeah, as a human being, so I didn't know what to do. What should I do? Or maybe the Brazil government didn't know whether they should accept me as a foreigner or whatever. So in this kind of uncertainty issues are all happening around. But the issue is that we cannot just evade and do nothing about, because we don't know what to do, because we don't know what the right answers about these issues. The issues is whatever solutions or choice we have to make, not just individually, but also government level or state level, even the kind of uncertainty situations. So this is kind of new challenges and new topics of public law issues and globally. So as a public law scholars, including me, nowadays I should say, yes, you are still quite young, and maybe your perspective about the future is generally quite positive and bright, but there are many issues surrounding us. As a public law professor, I'm debating and discussing how to understand these kind of new challenges in public law and public procurement issues too. And so let me add kind of artificial intelligence issues, adding another kind of dimension of difficulty, because before that, in the kind of public law decision makings, the key was finally came to human being as individuals in the private market and sphere, or public government officials. So they were still human beings. They did their best to make good choice or rational choice, or to optimize or whatever. But somehow nowadays, many the kind of human beings decision makings are substituted by data, huge data, or algorithm, or artificial intelligence. So in that kind of new world, so we need to think about, in a new stage, what is good choice, or what is rational choice. So whether how much we can believe in or rely on the decision making made by algorithm or AI. Maybe in the future, in the near future, human beings will be quite systemically separated from that kind of decision-making process, even in the procurement process. So, yes, I'm not providing you the answers to these questions, but I should say these topics are the trend and challenges to the modern public law issues. So because it is almost late in the night, I should stop saying now and should thank you everyone. Obrigado. Thank you.
Thank you very much, Professor Sang. And so, any other question? Alguma outra questão? Also, we have a reason for another lecture because Professor Kuzma lost his luggage, as we heard. So maybe a few years from now, we maybe have another lecture from you. So you bring your books that were lost in the plane. So again, thank you very much for the students that are here, and I would like to thank you as well, Professor João Augusto, that was the professor from business law, isn't it? Your course from today. So, vou falar em português para os outros professores que estão aqui. Gostaria também de agradecer ao professor Paulo Inácio, que dispensou a turma dele, né, de cadeia de suprimentos, para estar aqui presente. Professor Edmundo Inácio também, que está nos acompanhando remotamente, convocou os alunos, a professora Luciana. Professor Rafael Dias, que ofereceu a estrutura da DERE, né, para receber os nossos convidados. E a professora Luciana Souza, né, já falei. E o professor Luiz Eduardo Gaio, o nosso coordenador do curso de administração, que também nos ajudou com todos os preparativos. Então, para que todos estejam devidamente referenciados aqui na nossa palestra. So I think that's it. If no other question, if you know Professor João, do you want to?
Só avisá-los antes de sair, lá no fundo o QR Code para cada uma das turmas de vocês. Lista de presenças.
Okay, so thank you very much. Once again, Professor Kuzma, Professor Fausto, and Professor Sang. You are very welcome here in Brazil, in Unicamp. So I want to, Professor Paulo as well. Professor Paulo wants to. Ok. Vocês têm que estar de novo 9 horas na sala, o pessoal de cadeia de suprimentos, tá bom? Então é isso. Muito obrigado. Thank you very much.